It's kind of wild when you think about it. But for most companies these days, a huge chunk of their value, like over 80%, isn't tied to, tangible things like factories or equipment.
Right.
It's actually their IP, their intellectual property. And that's what we're going to really get into today, this whole idea of IP management and strategy and how it can make or break a company.
Yeah.
We've got some really interesting examples to kind of bring this all to life.
Yeah, and for this deep dive, we're really leaning on some insights from Dr. Benjamin DELSOL. He's a fractional chief IP officer, helps companies out with their IP. And he's a real thought leader, especially when it comes to these innovative deep tech companies. What's really cool about him is he's got this unusual background. He's got a PhD in quantum nanoelectronics.
Wow.
And a master's in IP law. So he brings this really unique perspective to, the whole world of innovation and how to protect it.
Yeah.
So we're kind of tapping into the expertise that he brings to his clients.
Exactly. So think of us as your guides today as we go through this sometimes complicated world of IP. We're going to be looking at the good, the bad, the companies that absolutely nailed their IP strategy, and the ones that learned some pretty hard lessons along the way.
Yeah.
Our goal is to give you a really solid understanding of what really matters with IP without, drowning you in legal jargon.
Exactly.
All right, so let's start at the beginning. For anyone who might be like, what is IP anyway?
Yeah, sure.
What are we actually talking about here?
Basically, IP, it's all about the things that people create with their minds, right? So any original idea that you come up with, like inventions or creative works or even, designs, logos, the names of companies, that's all intellectual property.
Got it.
And the law is there to give these creators, these owners, certain exclusive rights so they have control over how those creations are used.
Right. So it's like a temporary ownership of your innovative ideas.
Right.
So what are the main types of IP that are really important for us to get?
So there are a few key ones. First off, you've got patents.
Okay.
These are all about protecting new inventions or, new processes. So if you've created something totally new, it's not obvious to someone who knows that field, and it's actually useful, then a patent can give you the right to stop others from making, using, selling, or bringing in your invention from another country.
Right.
And this usually lasts for about 20 years.
Oh, okay.
And it's really important because it encourages companies to actually put money into research and development.
That makes sense.
Yeah.
You put all this effort into making something groundbreaking. You don't want someone just to copy it and sort of steal your thunder.
Exactly.
What's next in the IP world?
Well, then you've got trademarks.
Okay.
And these are about protecting those things that make your brand recognizable. So your company name, the logo, slogans, all that stuff,
Right.
They help customers know who you are, what your products are, and set you apart from the competition. And what's interesting about trademarks is they can last forever as long as you're using them and keeping up with the renewals.
Oh, wow.
It's all about building that brand recognition and, the positive feelings people have about your company.
So that iconic symbol or a catchy tagline, those are trademarks.
Right.
Got it. What about more creative works? How are those protected?
Yeah, so those would fall under copyright.
Okay.
And copyright protects original works of authorship.
Okay.
So that's books, music, movies, software code, even websites, all kinds of content.
Wow.
And generally, the protection starts as soon as you create something and put it in a tangible form. But registering it gives you a lot more legal muscle if someone tries to infringe on your work.
Got it. So if I write a song or code a program, it's automatically copyrighted, but registering gives you that extra legal backup.
Exactly.
Okay. What else is there?
So we've also got trade secrets. These are those bits of information that companies keep secret to stay ahead of the game.
Right.
Like a secret recipe for a popular food or a special way of manufacturing something. The key here is secrecy. As long as you keep that information confidential and it has commercial value, it's protected, potentially forever. Like think of Colonel Sanders' secret blend of 11 herbs and spices. He doesn't need a patent, just really good secrecy.
Right.
Yeah.
So is that the whole picture of the main types of IP?
Well, not quite. You've also got design rights.
Okay.
And these protect the way a product looks, the aesthetics, not the function.
Got it.
So a really strong IP strategy often uses a combination of these protections to create a kind of shield around their innovations and their brand.
Okay, that's a really helpful overview. So now let's dig into some real-world examples, the IP failures. We've got some pretty big cautionary tales, starting with a classic, the battle between Polaroid and Kodak. What went down there?
This is a really interesting story. It's all about patents and instant photography. So Polaroid, led by this visionary guy, Edwin Land, they were the kings of instant photography for years, right? And then they came out with this revolutionary camera, the SX70.
Right.
But then in 1976, Kodak, who had actually been supplying stuff to Polaroid, decided to jump into the instant camera market with their own cameras, the EK4 and EK6.
Okay.
And Polaroid immediately sued them, saying Kodak had infringed on like a dozen of their patents.
Wow. So for anyone out there developing new products, this raises a big question. How carefully are you checking existing patents before you go and launch a similar product?
Yes, absolutely.
And did Kodak think they'd managed to, avoid stepping on Polaroid's toes?
Yeah, they actually thought they were in the clear. Their engineers were confident they had cleverly designed around Polaroid's patents.
Uh-oh.
But after almost a decade of, really intense and expensive legal battles, the court sided with Polaroid in 1985. They said Kodak had infringed on 7 of their patents.
Wow. So what happened to Kodak?
Well, the consequences were pretty harsh. They got hit with an injunction, meaning they had to immediately stop their instant photography business.
Oh, wow.
They had to shut down production, stop sales, and millions of their cameras were essentially useless.
Oh, no.
And then they had to set up this really expensive buyback program to get those cameras back from customers. And in 1991, they were ordered to pay Polaroid a whopping $925 million in damages. That was a lot of money back then.
That's a huge price to pay for underestimating someone else's patents. But, this story doesn't end there, does it?
No, it doesn't. And this is the ironic part. Despite winning this massive legal victory, it didn't guarantee Polaroid's future.
Oh, right.
Digital photography was coming up fast, and instant film started to seem, kind of old-fashioned.
Right.
Polaroid struggled to adapt to this new world and actually ended up filing for bankruptcy in 2001. And Kodak, even though they took a big hit from the Polaroid settlement, they also faltered in the digital age and filed for bankruptcy themselves in 2012.
So it's like a legal triumph, but a market defeat for Polaroid. What are the big lessons here for us, for the listeners, from this battle?
I think there are a few really important takeaways. First, it shows how risky it is to ignore patent rights. Kodak's assumption that they could just work around them turned out to be a really costly mistake. Second, patent litigation, fighting over patents in court can be incredibly expensive and it can drag on forever. This case took over 14 years. And finally, even if you win big in court, it doesn't mean you're guaranteed success in the market. Companies have to be able to adapt to new technologies and market trends, which Polaroid, they just couldn't quite do. So for you, this means your IP strategy has to be tied to your overall business strategy, and you got to keep an eye on how technology is changing.
Right. That's a really powerful lesson. Okay, let's move on to another IP misstep, this time in the world of digital music, the Napster story. For anyone who might be, a little younger and doesn't remember, what was Napster all about?
So Napster, they launched in 1999, and they were this revolutionary service for sharing music. It was peer-to-peer file sharing, so users could share and download MP3 music files directly from each other's computers. They basically bypassed the traditional ways of getting music, and, importantly, they didn't worry too much about copyright.
Right. So,
And they got super popular really quickly.
yeah, but I remember it caused a huge backlash from the music industry.
Oh, absolutely. In 2000, Metallica and Lars Ulrich in particular, they filed this big lawsuit against Napster, saying they were enabling mass copyright infringement. It was a big deal, musicians going after a tech company. And then the big record labels jumped on board with their own lawsuits, saying Napster was making it way too easy to illegally copy their music. We even saw similar lawsuits later against platforms like YouTube.
And Napster's defense was, hey, we're just providing the technology, not the content.
Exactly. They said, we're just a platform, don't blame us for what users do. But the courts didn't buy it. They said Napster's whole business model was about making copyright infringement easy and encouraging it. And in 2002, Napster was found liable for contributory and vicarious copyright infringement.
And that was pretty much the end of Napster, right?
Yeah, it was. They had to shut down, make a public apology, and pay a ton of money in damages, up to $26 million, to settle the lawsuits.
So what's the takeaway here?
It shows that your business model has to respect intellectual property rights. You can't build a business on mass copyright infringement. If you're giving people access to content, you got to get permission from the copyright holders. You can't just say, hey, it's just technology, it's not our fault. Napster's failure was a turning point. It forced the music industry and tech companies to start figuring out legitimate ways to sell music online. It's something to think about, especially if your business is about sharing content. You have to make sure you're doing it legally.
Yeah, it definitely paved the way for, iTunes and Spotify and all that.
Absolutely.
Okay, let's talk about trademarks.
Yeah.
We've got a couple of interesting cases here, starting with Apple and their fight over the name iPad in China.
Oh, yeah. This is a great example of why you have to think globally when it comes to trademarks. Back in 2007, even before the iPad launched, Apple ran into a problem in China. There was this company, ProView Technology, and they said they already owned the iPad trademark in China. They had registered it for some other products. So for anyone thinking about expanding their business internationally, this is crucial. You have to make sure your trademarks are clear in every country you want to operate in.
So even Apple, this huge global company, didn't automatically own the name everywhere.
No, trademark rights are territorial. They're specific to each country. So just because you have a trademark in one place doesn't mean you have it everywhere else. And this caused a big legal battle for Apple just as they were getting ready to launch the iPad, especially in the massive Chinese market.
Yeah, not having the name would have been a disaster.
Totally. So after a lot of back and forth, Apple ended up paying ProView Technology $60 million in 2012 to settle the dispute and finally get the rights to the iPad name in China.
Wow, $60 million. That's a lot of money. What's the lesson here?
This shows how important it is to file for international trademarks early on. If you wait, someone else might grab your name in a key market, and then you'll have to pay a lot to fix it or even change your name in that market. It's all about doing your homework and making sure your trademarks are protected globally.
A costly lesson learned.
Mm-hmm.
Now, we've also got a trademark story about Coca-Cola, surprisingly, and a company called Manixie in the U.S. What happened there?
This is a really interesting one. It shows how important it is to actually use your trademarks. Coca-Cola had bought these popular Indian soft drink brands, Thumbs Up and Limca, along with their trademarks in India back in 1993, but they never really sold them in the US or registered the trademarks here. And then this company, Meenaxi, started selling drinks with the same names in the US in 2008, targeting Indian American communities, and they actually got US trademarks for those names in 2012. They even used logos and slogans that were really similar to Coca-Cola's Indian branding. It's a reminder that even if you have a famous brand in one country, you have to protect it in other countries, especially if you're thinking about expanding there.
So Coca-Cola tried to stop them.
Yep. They went to court to cancel Meenaxi's U.S. trademarks, saying they were misleading people. The trademark trial and appeal board initially started with Coca-Cola, but then Meenaxi appealed, and in 2022, the Court of Appeals for the Federal Circuit reversed the decision. They sided with Meenaxi. Yeah, they said Coca-Cola couldn't prove they had been armed in the U.S. because they weren't actually using or selling those brands here. So even though Meenaxi seemed to be copying, Coca-Cola's lack of action in the U.S. market hurt their case.
So even though it looked like Meenaxi was ripping off these well-known brands, Coca-Cola's own inaction in the U.S. market weakened their position.
Exactly. It shows that trademark rights are about actually using your trademark in a specific country. You can't just rely on being famous somewhere else. You have to actively use and register your trademarks in the markets where you want protection, and you have to be able to show that you've been harmed in that market if someone is infringing.
That's fascinating. Okay, let's move on to trade secrets. It seems like stealing trade secrets is a big problem, especially for tech startups.
Oh, it's a huge problem. Because trade secrets are all about secrecy, they're vulnerable to theft, and often it's employees or former partners who do the stealing. And unlike patents, they don't expire, but once the secret is out, the protection is gone. It's a constant battle to keep things under wraps.
And we've got some examples here that really illustrate the risk.
Yeah, for example, there was a biotech startup whose CFO allegedly stole sensitive data, including their tech, right before leaving to join a competitor. The court had to issue a restraining order to stop them. Then there was this Insurtech company that sued a former director in his new company because they allegedly stole trade secrets about their software and business model.
Wow. So it's not just small companies that are vulnerable.
No, not at all. We've seen huge cases with companies like Eli Lilly, where employees stole drug secrets, Tesla, where an engineer was accused of taking AI secrets, and even Samsung, where an exec tried to basically build a whole chip factory in China using stolen blueprints and by poaching employees. It happens everywhere.
It's like corporate espionage.
Hmm.
So what are some of the things that make companies vulnerable to this kind of theft?
There are a few things. One is giving employees access to more information than they need to do their jobs, not following the need to know rule. Then there's weak cybersecurity. If you don't have strong passwords, two-factor authentication, encryption, and other protections, it's easy for people to steal data. Also, sloppy onboarding and offboarding processes for employees can be a problem. And sometimes companies don't even know what their trade secrets are, so they don't protect them properly. It's a wake-up call for everyone to really think about their security protocols.
And the consequences can be devastating, especially for startups.
Right. Absolutely. For a startup, their whole business might depend on one innovation that's protected as a trade secret. If that's stolen, they lose their competitive edge, they lose opportunities, they lose money, they get bogged down in lawsuits, their reputation is damaged, and in the worst case, they go out of business. Even for big companies, it's a huge setback. It's always better to invest in protecting your secrets up front than to deal with the fallout later.
Yeah, prevention is key. Okay, so we've seen what can go wrong with individual cases of IP failure. Now, let's look at the bigger picture. The cost of mismanaging IP in general.
Right. It's not just about these specific lawsuits. There are huge financial penalties and legal fees involved. Like we saw with Polaroid and Kodak, the damages can be enormous. And in the US, if you intentionally infringe on a patent, the damages can be tripled. Even small IP disputes can cost millions in legal fees. And that's not even counting the cost of investigating breaches and trying to repair your reputation. So neglecting IP is a big financial risk.
And it's not just about money, right? There can be serious disruptions to your business.
Exactly. Like in the Kodak case, if you lose an infringement lawsuit, you might be banned from selling your product. You might have to stop production, redesign things, or even shut down entire parts of your business. That kind of disruption can really hurt your operations and your revenue. So it's really important to make sure you're not infringing on anyone else's IP before you launch a new product or service. That's where freedom to operate analysis comes in.
And then there's the reputational damage, which is hard to measure, but it can be just as bad.
Oh, absolutely. If you're caught stealing ID or if you're found guilty of infringement, it can really hurt your company's image. Customers, investors, and partners might lose trust in you. They might see you as unoriginal or unethical. And if your trademark is used without permission, it can weaken your brand. That's called trademark dilution.
And if your IP isn't protected, you can lose your competitive advantage, right?
Definitely. Competitors can take advantage of your inventions or trademarks if you're not careful. They can copy your ideas and steal your market share. Think about Napster. They couldn't operate legally, and they ended up losing everything. So being proactive about IP protection is crucial for staying ahead of the competition.
And weak IP protection can even make it harder to get investment or sell your company later on.
For sure. Investors and buyers are wary of companies that have IP problems. They want to see a strong IP portfolio. It's a sign that the company is valuable and worth investing in. If you have messy IP documentation or unclear ownership, it can scare away investors. And if your IP is stolen, it can seriously devalue your company overnight. So if you're looking for funding or planning to sell your company someday, your IP situation is a big factor.
And it can limit your future opportunities, too.
Definitely. If you have a bad reputation because of IP issues, other companies might not want to work with you. And if you don't have the right IP protection in certain countries, you might not be able to expand into those markets, like we saw with Apple in China and Coca-Cola in the US. In the end, mismanaging your IP can create all sorts of risks that can really hold your business back. You have to think about IP as an ongoing part of your overall business strategy, not just a one-time thing.
So we've explored the dark side of IP, the things that can go wrong. Now let's look at the bright side. The companies that have used IP to achieve amazing success, where should we start?
Let's start with the pharmaceutical industry. They're a great example of how patents can create market exclusivity and drive innovation. Developing a new drug is super expensive and risky. It can take over 10 years and billions of dollars.
So patents are their lifeline.
Pretty much. Patents give them the right to sell their drug without generic competition for about 20 years. That lets them set prices that allow them to recover their R&D costs and invest in more research. Without patents, there's just not enough incentive to develop new drugs. So for anyone in an industry that's heavy on innovation, think about how patents can give you that breathing room to make your money back and invest in the future.
And they're really strategic about how they use patents,
Right.
right?
Oh yeah, they use what's called layered protection. They file multiple patents on different aspects of a drug. Not just the active ingredient, but also the formulation, the dosage, the treatment methods, even the manufacturing process. They also try to find new ways to deliver existing drugs or repurpose them for new uses. And they create combination therapies. It's all about building a wall around their product to keep generic competitors away and as long as possible. A strong patent portfolio is one of the most valuable things a pharmaceutical company can have.
Patents are the foundation of their whole business model. Okay, what's another example?
Let's talk about Qualcomm. They've built a really successful business by developing and licensing intellectual property, mainly patents on wireless communication tech like 3G, 4G, and 5G. They're a great example of how to make money from fundamental innovation.
So they're not just making chips, they're also making money from their inventions through licensing.
Right. They invest a ton in R&D, like 20% of their revenue each year since 2006, which adds up to over $100 billion. And then they license their patents to pretty much every major phone maker and a bunch of other companies in the mobile world.
So if you're making a smartphone, you're probably paying Qualcomm something.
Most likely. Their licensing division has hundreds of licensees, and their patents are used in billions of devices worldwide. This brings in a huge and steady stream of revenue for them, separate from their chip business. It's an impressive model.
So strategically patenting key technologies and then licensing them widely, that's the Qualcomm playbook.
Okay, who else is a master of IP strategy?
You can't talk about IP success without mentioning Disney. They're the ultimate example of how to leverage copyright and trademarks. They've built a global empire by creating beloved characters, acquiring iconic franchises, and protecting their IP fiercely. For anyone interested in branding and content creation, Disney is a textbook case.
From Mickey Mouse to Star Wars, they've got some seriously valuable IP. They do. Their strategy is multi-layered. They create original characters and stories, but they also make smart acquisitions like Pixar, Marvel, and Lucasfilm, which brought them whole universes of IP. And then they monetize everything across multiple platforms, movies, theme parks, merchandise, streaming services, and they're really aggressive about enforcing their rights. They use both copyright to protect their creative works and trademarks to protect their branding. Even as some of their early copyrights expire, like the original Mickey Mouse, their trademark on Mickey as a brand remains super strong.
And I've heard they've even influenced copyright law itself.
That's right. They've lobbied for longer copyright terms, which has actually changed copyright law in the US. They spend a huge amount of money every year on IP, which shows how important it is to them. They're not afraid to use public domain material for inspiration, but they protect their own creations fiercely.
For them, IP is the core of their business. So we've talked about big companies. Can smaller businesses use IP to succeed too?
Absolutely. Take music licensing platforms, for example. Companies like Easy Song Licensing and others have built successful businesses by making it easier to license copyrighted music.
So they're simplifying the process of using music legally.
Exactly. They acquire or represent the rights to a lot of music, and then they offer easy licensing options through online platforms. This makes it much simpler for creators and businesses to use music without having to negotiate complicated deals with individual copyright holders. They've shown that managing and licensing copyright can be a very successful business model.
It's interesting how copyright is the foundation for these businesses. Okay, what about trade secrets? We've talked about the risks, but are there any success stories there?
Definitely. While patents expire and require you to disclose your invention, trade secrets can last forever, as long as you can keep them secret. Think about iconic examples like Coca-Cola's formula, Google's search algorithm, and KFC's secret recipe. These trade secrets have been valuable for decades. The key to their success is constant vigilance, tight security, limited access, non-disclosure agreements, and strong cybersecurity. For some kinds of information that are hard to figure out, trade secrets can be incredibly powerful for staying ahead of the competition.
It's amazing how those secrets have stayed valuable for so long. We also have a case study about a smaller company in Cambodia, Lai Food Industry. How did they use IP to succeed?
Live food industry shows that even basic IP rights, like trademarks and packaging design, what's called trade dress, can make a big difference even for smaller companies in developing markets. The founder, Mrs. Kiyomom, was smart about IP from the beginning. She registered her company name and her logo as trademarks back in 2003. She was also the first in her area to use plastic packaging for her rice crackers, which made them stand out. She kept improving her packaging and built her brand around quality and health. This focus on branding and packaging helped her build a strong reputation, gain customer trust, and grow her business significantly. It's a great example of how even simple IP tools can be powerful when you use them strategically.
It's inspiring to see how trademarks and design can transform a business. So thinking about all these stories, what are some of the common IP mistakes that we should avoid?
There are a few classic pitfalls. One is simply not identifying and protecting your IP in the first place, which happens a lot with startups. Another is forgetting that IP rights are different in every country. We saw that with Apple and Coca-Cola. Not having clear ownership records or good security for trade secrets is another problem. A lot of companies also don't actively monitor and enforce their IP rights. And some companies forget to check if they're infringing on someone else's IP before launching a new product, like what happened to Kodak. Sometimes companies even pursue IP protection that doesn't really fit with their goals. And finally, underestimating the cost of IP lawsuits or failing to adapt your IP strategy as your business changes are common mistakes.
So what are some best practices for managing IP effectively?
The most important thing is to make sure your IP strategy aligns with your overall business strategy right from the start. You should regularly review your IP to see what you have, what's missing, and what risks you're facing. Make sure you protect your key IP early on using a combination of patents, trademarks, and other tools as needed. Be clear about who owns what and keep good records. If you have trade secrets, protect them carefully. Limit access, use non-disclosure agreements, train your employees, and have good offboarding procedures. Always check if you're infringing on someone else's IP before you launch a new product. Think about how you can make money from your IP, maybe through licensing or partnerships. Create a culture where everyone in your company understands the importance of IP, and keep reviewing and updating your IP strategy as your business grows and the market changes.
Those are some really practical tips that anyone can use. So wrapping up our deep dive today, it's clear that in today's world where knowledge is so important, IP is a powerful tool. It can make or break a company. We've seen how important it is to be proactive, to respect the IP rights of others, and to protect your own innovations.
Exactly. And the insights we've shared are similar to what experts like Dr. DELSOL provide to their clients. With his unique background in both science and law, he helps companies make the most of their IP and use it to grow their business.
So for you, our listener, think about this. What's one thing you could do right now to understand and leverage the value of IP in your own work or field? In a world where ideas are currency, how will you make sure your intellectual assets are working for you? We encourage you to keep learning about this fascinating and important topic. Thanks for joining us for this deep dive.